Welcome back, everybody. We have new updates for you in the Murdaugh saga. The family of boat crash victim Mallory Beach is officially taking Murdaugh and a convenience store chain to court in August. The civil lawsuit stems from an incident in February 2019 involving Murdaugh's now deceased son, Paul. The 19-year-old was driving a boat in the middle of the night while drunk and crashed into a bridge at high speed. 19-year-old Mallory Beach was killed and several other boat passengers were injured. According to investigators, Paul used his older brother Buster's ID earlier in the night to buy beer at Parker's Kitchen, a convenience store in South Carolina. Beach's family is suing the franchise itself and the specific cashier that rung up Paul, claiming they, quote, knowingly sold alcohol to a minor. Parker's Corporation filed a motion earlier this month to throw out the lawsuit, denying negligence and all other claims. They believe that the store clerk obeyed store policy by scanning a valid ID, and everyone entered the boat at their own risk, knowing that drinking would be taking place. The judge ultimately sided with the plaintiffs, letting the case go to trial on August 14th. Let's break it down. So, Brian, it seems like the judge is siding with the Beach family lawyer by denying the motion to dismiss the lawsuit. What was Mark Tinsley's strongest argument for the plaintiffs? And everybody will remember him from testifying in Alec Murdaugh's trial.
Yeah, Jesse, I think the strongest argument here is probably the one that he won on, and that is these arguments are factual ones, at least the ones that the defense, or that the plaintiff, had strong arguments for. But the other ones that he won, they were legal and they won. But factual arguments, those are supposed to be decided by the jury, not the judge. So if we're asking the question from a factual standpoint, whether or not someone is negligent, it's not the judge's role to weigh facts and see whether or not this law applies. That's where a jury comes in. So I think the judge was right to side with Tinsley and say, hey, we've decided whether or not there's a duty. We've decided whether or not there's injury. Those are legal standards. But this question of negligence, it's not for me to decide. Go on to the jury. Now, it's not the worst thing for the defense. They can still potentially win this in front of the jury. It's just not in front of the judge.
Terry, what happens if the convenience store loses the case? What type of penalties could they ultimately face here?
You know, this could be a huge loss if they lose this case. It is a wrongful death action, and as Brian mentioned, you do have to show that the store and the person who sold that alcohol had a duty of care to the customer. And I do think they're going to be able to show something to that effect, and they're going to be able to show you have to use reasonable care when you're operating a premises like that. So I do think that there was a duty to train the person who sold the liquor, and I do think that that did occur. There's some evidence to that effect, and if they can prove that, then maybe they can prevail. The damages are going to be huge. They've asked for actual costs and punitive damages, and under the Unfair Trade Practices Act, they've asked for treble damages, so it could be a lot of money.
The ripple effects from the Alec Murdaugh saga continue. The criminology student accused of brutally stabbing 4 young people to death at the University of Idaho has officially entered a not guilty plea to multiple charges of murder. Brian Coburger was back in an Idaho courtroom for arraignment after a grand jury indicted him last week. Coburger appeared alongside his public defender, Ann Taylor, as the judge laid out the charges. Law and Crime correspondent Anjanette Levy was inside the courtroom and has all the details.
This was the first time that we have seen Brian Coburger in a courtroom since January, and he really looked the same as Judge John Judge read the 4 murder counts to him and the 1 burglary count that he faces.
Mr. Coburger, do you understand the charge in count 1, burglary?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 2, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Brian Coburger answered yes, forcefully and confidently, when he was asked whether he understood the 4 murder charges and 1 burglary charge that he faces in the murders of Maddie Mogan, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin.
Okay, Ms. Taylor, is Mr. Coburger prepared to plead to these charges?
Your Honor, we will be standing silent.
Okay, because Mr. Coburger is standing silent, I'm going to enter not guilty pleas on each charge.
Coburger has the right to a speedy trial, but his public defender requested a date just outside of that time frame.
Your Honor, we'd ask the court to set this trial at the very outside of the speedy trial, right? We're not prepared to do anything but ask the court to do that today.
For now, the trial is scheduled for October 2nd of this year. Prosecutors have 60 days to let the defense know whether or not they will pursue the death penalty. At one point, Judge got some of the names of the victims wrong. He called Kaylee Gonsalves Kayla. That upset her older sister, who told a representative of the court that it was disrespectful, and getting her sister's name right is important. For Law and Crime, I'm Anjanette Levy in Moscow, Idaho.
All right, I want to bring in our legal analyst, defense attorney Brian Buckmeyer, former trial attorney Terry Austin. There were some issues discussed after Monday's arraignment, including a motion to compel discovery. Coburger's attorneys are requesting that the court order prosecutors to turn over any exculpatory evidence. The defense thinks that the state has evidence that could help clear Coburger's name, but the state wants the defense to provide more information on what it thinks they have, since they've already turned over a mountain of evidence. So, Terry, the defense team has requested multiple items, including all videos, all lab reports, all interrogation notes, and even police training records. How could this evidence actually be helpful to their case?
Well, you know, discovery disputes, they're always interesting to me. The prosecution claims that it produced a mountain of evidence, including over 10,000 pages of written materials. But the defense claims that not everything has been produced, and specifically they allege that the prosecution is holding on to exculpatory evidence which could prove Coburger's innocence. Two items in particular were requested by the defense. They wanted to shed some light on their strategy. The first item includes the interrogation notes from Detective Payne. Perhaps Coburger said something to the detective about something that could help his case. The second item involves police training records. I guarantee you, Jesse, at trial, the defense will claim that the detectives failed to properly investigate the case. So no matter what the judge decides, the prosecution does need to turn over any and all exculpatory evidence. Otherwise, they'll be severely punished.
Exculpatory evidence, that is a big key right now. One of the big questions from today's hearing from our viewers, and also some from our own producers, is why would Coburger choose to stand silently instead of saying he pleads not guilty? Well, Brian, is there any kind of legal strategy behind that?
I mean, if potentially irritating the judge and others in the case is a strategy, or making them think that you're scheming or not taking it seriously, then yes. Otherwise, no. Legally speaking, Coburger pleading not guilty on his own, his attorney doing it on his behalf, or even judge entering it on Coburger's behalf while he stands here in court, there's no real difference. But in terms of optics and what is in the mind of Coburger, it could mean a lot. It's not secret that in the court of public opinion, this looks like a bit of a defiance on Coburger's hand. Maybe the charges and the proceedings will show us more as the case continues, though.
Or maybe he's just saying, I might be open to take a deal, might be able to negotiate. Maybe I'm saying, hey, I'm pleading, not even pleading not guilty here, keeping his options open. Just a theory. Well, the investigation into the horrific killings of the Idaho Four has cost the small area of Moscow, Idaho, a significant amount of money. The city's mayor says that they're already working on a very slim budget, and the police department in general takes up the largest amount of that funding. But now that the city has stepped up patrols, overtime pay is mounting. Before the murders, Moscow leaders had already planned a tax hike to go towards city projects, but instead, all extra money has been diverted to the police department. So far, Idaho's governor has reimbursed the city around $93,000.